So let's talk a little bit about the difference between a bench trial and a jury trial. So if you're the person accused of a crime, a defendant in a criminal case, and you're unable to resolve the case through pretrial negotiations, then the next step is to set your case for trial. And at arraignment, that's when you plead either guilty or not guilty, and you enter not guilty pleas to set your case for trial. You'll have the option of going to trial in front of a jury, but you can also waive that right and ask for a trial in front of just the judge. And so that is called a bench trial. Now, if you waive your right to a jury and request a trial in front of the judge, the prosecution can object, although they rarely do, and ask for a jury trial. And if either party in a case asks for a jury trial, then the judge has to grant a jury trial. So both the prosecution and the defense have a right to a jury trial in any criminal case. So the difference between a jury trial and a bench trial is that in a bench trial, the judge makes both legal and factual decisions. So in a traditional trial, there's kind of a delegation of authority where the judge is responsible for making legal decisions in the case, and it's the jury that determines the facts. So I'll give you an example. In a traditional case, if a party makes an objection, well, an objection is an argument about the admissibility of evidence. It's a legal argument, right? And so that's why a judge is the person that decides whether or not the objection should be granted and that evidence should be kept out, or the objection should be denied or overruled and that evidence should be allowed in. So that's a legal decision. The same thing goes for the jury instructions in a case. When the case is concluded and the jury is sent back for deliberation, they're given a huge packet of instructions, and that tells them the law that they have to follow. Now, the person who decides what instructions to give the jury is the judge, right? The judge is making a legal determination about what laws should apply in the case and then turning that over to the jury. Now, when the jury goes back to deliberate, they're supposed to make factual decisions in the case. So they decide what happened. And the way they do that is they evaluate the credibility of the evidence that was brought in front of them. So credibility means that they are deciding who to believe, what to believe, and how much of the evidence to believe. And so that's why a jury is the person that says whether or not a defendant is guilty or not guilty in a traditional case, because ultimately the decision of guilt or innocence is determined based on what facts are considered to be valid or reliable or believable, right? That's the jury's role, is to decide what facts to believe. And based on that, they decide if somebody was guilty or not guilty. So in a bench trial where the jury is not impaneled and does not make those determinations, then it's the judge that not only decides the law, but also decides the facts in the case and ultimately decides whether or not a defendant is guilty or not guilty. So when, if ever, would it be a good decision to waive your right to a jury trial and go to trial in front of a judge in just a bench trial? So many defense attorneys are would answer that question with the answer never, right? There are a lot of advantages to going to trial in front of a jury. If you have a trial in a felony case, that means that there are 12 people that are going to have to come to a unanimous verdict that the defendant committed the crimes alleged beyond a reasonable doubt in order to enter a finding of guilty against that person. Well, it's really hard to get 12 people to agree on anything. And if they're unable to come to a unanimous verdict about all of the elements of the charge, then they can't find not guilty. And even if they're unable to come to a unanimous verdict of not guilty, that the DA hasn't met their burden, they still cannot convict. So if that happens, if the jury cannot reach a verdict, then that's called a mistrial. And that means that the case has to be retried at a later time in front of a different jury. So if you have 12 people charged with making that determination, then, to some degree, to win that trial, all you have to do is get at least one person to agree that the DA has not met their burden. So that is a powerful tool in the defense arsenal if you are contesting the guilt of your client. So it's a very good thing to have a jury in that context, because you've got 12 chances of getting somebody to agree that the DA hasn't met the burden. And cases that are mistried and have to be brought to trial again, well, then you've got well, at least the DA knows at that point that their case isn't as strong as they thought in the first place. And oftentimes you get a more favorable plea offer before that next trial. At the very least, the DA's playbook for the next time that trial comes around. So there's certain advantages even in a mistrial. Okay, so when, if there's such an advantage in going to trial in front of a jury, when would it be a good decision to waive your right to a jury trial and go to trial in front of a judge? There's only really, I think, 3 instances where I think that would be a good decision. So, one of those circumstances would be in a case where the defense is very, very technical. And the reason that it would be good to go to trial in that case is because judges are more likely to, get really involved in a technical argument in a case and be more willing to grant an acquittal based on a purely technical argument than a jury would likely be. So here's an example. Think of a case where you have a DUI charge, right? And it is abundantly obvious that the person was intoxicated. So, there's a car accident that results from somebody swerving all over the road, and they get out of the car, and there's a bunch of witnesses that see them falling over, throwing up. The police are called. The police respond. That person confesses, says they had, a dozen drinks, and there's beer bottles in the back, right? I mean, there is no question that this person was incredibly intoxicated and driving the car, okay? So the question of whether or not this person's going to be convicted of a DUI, that's solved, right? If you're going to trial, that person is going down on DUI. But then think of this, in this particular circumstance, as a situation where their blood alcohol content, which is the amount of alcohol per milliliter of blood in your system at the time of driving. So their blood alcohol content comes back at a 0.206. So that number is important for a number of reasons. In Colorado, there is a law that says that if your blood alcohol content is above a 0.2 on a first offense, then even though it's a first offense, you have to do 10 days jail or work release upon conviction. Okay? So that's a pretty serious issue for a lot of people, especially, somebody that's never had to be incarcerated before. A person in that situation, their main goal oftentimes is to avoid doing any kind of jail time, even knowing that they're going to go down and be convicted of the DUI. Most people on a first offense are getting probation, so that mandatory jail time is significant. So in that situation where you have a blood alcohol content of a 0.206 and a law requiring you to do 10 days jail if your blood alcohol content is above 2, means that the entire trial is really going to be about the person's blood alcohol content at the time of driving, and if that level, 0.206, is accurate. And it turns out that it's not necessarily accurate. And here's what I mean by that. There is a range of error for the test, for the blood test, that the laboratories here in Colorado have. And that range of error is a 0.01 for any test of somebody's blood alcohol content. And it's a plus or minus 0.01, right? It means the test can be 0.01 below that level, and it can be 0.01 above that level. The forensic toxicologists who do this test cannot say with definitive accuracy if the test should be 0.01 higher or if it should be 0.01 lower. All they can say is that the test is within that range of error. So in our situation, where somebody was driving with a 0.206 blood alcohol content, what that means is that their blood alcohol content could have actually very well been below that 0.2 number because it falls within that range of error. And so in this situation where you have a person having to go to trial on the case and being unable to get to a resolution that doesn't involve any jail time, well, then that is one of the situations where you may want to go to trial in front of a judge, because the judge is a lot more inclined to understand this technical argument about the range of error and understand that the DA cannot prove beyond a reasonable doubt that this person's blood alcohol content was above a 0.2. A jury may be less likely to understand that argument and give it the kind of validity that it deserves when they're looking at the case, because all they're going to see is this person's behavior, which makes them seem very drunk, and they very well may be inclined to believe that, well, if you're that drunk, then you're going to be above a 0.2. So that's an example where you can do better in front of a judge than a jury. Another example, a person who is unlikely to receive a fair trial because of some status that they have. So, in Colorado, if you receive a felony conviction, then that means that in the future, if you testify in court, the DA is allowed to bring up the fact that you have a prior felony conviction as evidence that your testimony should not be believed, right? So they're allowed to argue that whatever you said should be disregarded because you have the status as a felon. Now, they're not allowed to argue that because you committed this felony in the past, you committed this crime. That would be arguing that you have a propensity for crime. But they are allowed to say that your testimony shouldn't be believed because you've been convicted of a felony before. All right? And the judge gives a jury instruction that says that very thing, that you're not allowed to consider the evidence of somebody's felony for any reason other than how it impacts their testimony. But what frequently is the case, and what most defense attorneys will acknowledge, is that it's very, very difficult for jurors to do that. And they will tell the court that they're willing to follow the law, and they'll tell the parties that they're willing to follow the law. But frankly, when people get back into the jury room, it is very difficult, if not impossible, for them to divorce the understanding that somebody has a prior felony conviction from their evaluation of the case itself. And what ends up happening is that a lot of times people with a prior felony conviction get convicted of a new offense because the jury goes, well, if they did it before, they probably did this thing, they probably did it again, even though those two crimes may be wildly different, and even though the range between when you got that felony conviction and when you've been charged with this new crime has been, years, even decades. And in Colorado, DA can introduce a felony conviction from whenever. There's no timeline that precludes them from introducing a felony conviction. So even if it's a felony conviction from 30 years prior, they can bring that in to challenge your credibility if you're the defendant in a case and you're testifying. So in a situation where somebody has very compelling testimony to offer, but it's going to come out during that testimony that they have a prior felony conviction, that may be a good time to take the case to a judge rather than a jury, because judges see people with felonies all the time, and they don't automatically discount your statement because you have a felony conviction, because they see so many people in that situation, and they know that doesn't automatically make you not a credible person or more likely to commit a crime in the future. And it's easier for them to divorce that belief, that propensity belief that because somebody did a crime in the past, they'll do it again, than it is for a jury. So those are two examples of situations where it may be a good idea to do a trial in front of a judge rather than a jury. The last example is not, more of a strategic decision than a result of a necessity, and that has been the COVID lockdowns and how that has impacted our criminal justice system. For almost a little over a year, jury trials in Colorado were not taking place. That was because the chief judges in these different districts decided, and even the chief judge of the Supreme Court at one time decided that it was too much of a risk to impanel jurors together to try these cases, because that meant that there were going to be too many people in close proximity, and there was not a way to safely conduct a jury trial. And so jury trials were suspended and not taking place, which means that people who had pled not guilty to the crimes that they've been accused of committing were not able to go to trial and have their cases decided. And, that wasn't necessarily particularly egregious for people who were out on bond and still in the community and still able to go about living their lives. But for people who were incarcerated and unable to post bond because that they've been accused of these crimes, those people were significantly prejudiced, and their cases were being continued kind of indefinitely without their ability to resolve those cases with a trial. And so many of those individuals waived their right for a jury trial so that they could go to trial while that pandemic was ongoing in front of a judge. So fortunately, I think that the worst is over. I'll knock on wood for that one, and that we've been resuming jury trials for the last month or so, and I hope that we're going to continue to do that, and that won't be the situation anymore. But that has been the third reason that I've seen for people to go to trial in front of a judge rather than a jury, was just to make that trial happen in the first place. So that is my analysis of when it can be a good idea to go to trial in front of a judge rather than a jury. Those are some very, very limited exceptions. For the most part, a jury trial is almost always going to be the right decision. But there are some times when it's the right call to waive that and trust the judge with making both the legal and the factual decision in a case. So my name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado. I believe in the Constitution, and I want you to know the law and know your rights.